Members of the jury, have you reached a verdict?
We have, Your Honor.
The court has considered the evidence presented and the arguments of counsel and find the verdict of the jury to be supported by the record. Judgment is entered accordingly. That is the order of the court.
In October 29, the New York County Supreme Court was filled with tension as Philip Marshall sat in the gallery, waiting for the verdict in the trial against his father, Anthony Dryden Marshall. The case had lasted 135 days and centered around accusations that Anthony had exploited his mother, the beloved philanthropist Brooke Astor, for financial gain. After Brooke's death in 2007, Philip, her grandson, became the whistleblower, filing the lawsuit and testifying against his father. The trial was a battle over whether Anthony was a devoted son or a thief who had stolen $60 billion from his elderly, Alzheimer-stricken mother. For Philip, this trial was not about money. It was about family and moral integrity. Philip had seen firsthand how his father had manipulated and isolated his mother in her final years, stealing her wealth and diminishing her quality of life. After nearly 2 weeks of deliberation, the jury returned with their verdict on October 8, 2009. Anthony Marshall was convicted of all 14 charges, including grand larceny and conspiracy. His co-defendant, Francis Morrissey, was also convicted on 6 counts related to fraud. As the verdict was read, the courtroom erupted. Reporters scrambled for phones, spectators whispered, and some cried. Yet, Philip remained still, overwhelmed by sadness and exhaustion rather than victory. Despite the public and legal win, Philip felt a profound loss. The man who had raised him, whom he had once admired, had been convicted of crimes that forever shattered their family. Anthony had become a thief, a man who manipulated his own mother for personal gain. The family they had once been was gone, and no legal victory could change that. Brooke Astor, a New York icon, had been vulnerable in her final years. Struggling with Alzheimer's, she was unable to defend herself as her son exploited her for millions. Philip, who had watched the decline of his grandmother, took the difficult step of confronting his father. It cost him relationships within the family, and he was vilified as a traitor, but he knew he had to act. This case became a landmark in exposing elder abuse, highlighting how even family members can exploit their vulnerable loved ones. For Philip, the trial was a painful journey. The verdict brought justice to his grandmother, but the emotional toll was immense. He had lost his father, the man who once taught him about honor and family, and now that relationship was forever broken. In the end, this story is about more than a trial. It's about the deep cost of standing up for what's right, even when the person you're fighting against is your own blood. It's about betrayal, loss, and the moral struggle of seeking justice in the face of familial love. To understand what Anthony Marshall stole, one must first understand who Brooke Astor was. She wasn't just wealthy. She was Brooke Astor, a name synonymous with New York City philanthropy, grace, and generosity on a scale that defined an era d'art. Born Roberta Brooke Russell on March 30, 1902, in Portsmouth, New Hampshire, she'd lived through most of the 20th century. She'd been married 3 times. First to J. Dryden Marshall, a Princeton man from a wealthy family, then to Charles H. Marshall, a stockbroker, and finally, in 1953, to Vincent Astor, one of the wealthiest men in America and the great-great-grandson of John Jacob Astor, the fur trader who'd built one of America's first great fortunes. Vincent Astor died in 1959, leaving Brooke a widow at 57. He also left her control of the Vincent Astor Foundation, with assets worth approximately $67 million, equivalent to over $600 million today. Brooke could have lived a life of leisure. She could have traveled the world, collected art, attended galas, and spent her days in pampered retirement. Instead, she spent the next 50 years giving it all away. She became the most celebrated philanthropist in New York City history. She funded the renovation of the New York Public Library, giving millions to restore the iconic building at 42nd Street and 5th Avenue. She supported the Metropolitan Museum of Art, the Bronx Zoo, the Morgan Library, and dozens of smaller cultural institutions. She funded affordable housing projects in Harlem and the South Bronx. She supported public schools, hospital pediatric wards, parks and playgrounds. She believed, genuinely, passionately, that wealth came with responsibility. That those who had money should use it to make the world better for everyone, not just themselves. "Money is like manure," she famously said. "It's not worth a thing unless it's spread around encouraging young things to grow." By the time she reached her 90s, Brooke Astor had given away nearly $200 million. She was beloved by New Yorkers across all economic classes. Politicians sought her endorsement. Artists and writers sought her patronage. Society columns covered her every appearance. She wrote best-selling memoirs. She hosted legendary dinner parties. She wore Givenchy gowns and walked her dachshunds through Central Park. She danced with presidents and lunched with celebrities. She was, in every sense, New York royalty. But behind the elegant facade, behind the carefully curated public image, Brooke Astor was also a mother. And her relationship with her only child, Anthony Dryden Marshall, Philip's father, was complicated, strained, and ultimately tragic. Anthony had been born in 1924, Brooke's son from her second marriage to Charles Marshall. He'd grown up in the shadow of his mother's glamorous life, watching her marry Vincent Astor and transform into a social icon. By all accounts, their relationship was cordial but distant. Brooke was busy with her philanthropy and social obligations. Anthony pursued his own career, serving in the Pacific during World War II, working in various business ventures, and eventually becoming involved in managing his mother's charitable foundation. But those close to the family whispered that Anthony always felt overlooked, that he resented his mother's devotion to charities at the expense of family, that he believed he deserved more recognition, more gratitude, more money. In 1992, Anthony married Charlene Gilbert-Ottstott, a former television producer and socialite. It was his third marriage. Charlene was younger, ambitious, and according to some of Brooke's friends, increasingly influential over Anthony's decisions. And in 2001, when Brooke Astor was 99 years old and beginning to show signs of cognitive decline, she made a decision that would seal her fate. She gave Anthony power of attorney. She trusted him. She believed her son would care for her in her final years with the same devotion she'd shown to the city she loved. That trust was misplaced. The early signs were subtle. In 2000, Brooke Astor was 98 years old and still sharp. She attended charity events, gave interviews, and maintained her legendary social calendar. But those closest to her noticed small changes. She repeated stories. She forgot names of longtime acquaintances. She seemed confused about dates and appointments. In late 2000, her doctor, Howard Phillott, a prominent geriatrician and Alzheimer's specialist, conducted a comprehensive evaluation. The diagnosis was inevitable: early-stage Alzheimer's disease. The prognosis was grim. Alzheimer's is a progressive, degenerative brain disease with no cure. Over time, Brooke would lose her memory, her cognitive function, her ability to recognize loved ones. Eventually, she would lose herself entirely. Dr. Phillott explained this to Anthony. He emphasized the importance of maintaining Brooke's quality of life, keeping her engaged socially, ensuring she received excellent medical care, and protecting her from financial exploitation during periods of confusion. Anthony assured the doctor he would do all of this. In 2001, at Anthony's suggestion, Brooke signed a durable power of attorney, designating Anthony as her agent. This legal document gave Anthony sweeping authority over Brooke's financial affairs. He could access her bank accounts, sell her property, manage her investments, and make decisions about her estate. It was a position of extraordinary trust, and almost immediately, Anthony began abusing it. The money starts flowing, 2002 to 23. According to financial records later examined by forensic accountants, Anthony's compensation from his mother's estate changed dramatically after he received power of attorney. From 1995 to 2001, Anthony received approximately $200,000 per year from Brooke, a combination of gifts, loans, and payments for serving on the board of the Astor Foundation. This was generous, but not extraordinary given Brooke's wealth. But in 2002, Anthony's annual income from his mother's estate jumped to over $1 billion, then $1.50 million in 2003, then $2 billion in 2004. The money flowed in various forms, gifts. Anthony characterized many of the transfers as gifts that Brooke wanted him to have. But there was no documentation of these alleged wishes, no letters, no emails, no witnesses who could confirm Brooke had actually requested these transfers. Loans that were never repaid. Anthony borrowed money from Brooke's accounts with vague promises to repay. The loans were never repaid, and no one pressed him for repayment because he controlled the accounts. Increased allowances. Anthony increased his own monthly allowance from Brooke's estate from approximately $16,000 per month to over $83,000 per month, a 500% increase. Consulting fees. Anthony began billing Brooke's estate for consulting services related to managing her properties and charitable giving. These fees totaled hundreds of thousands of dollars per year and were never documented with invoices or timesheets. Where did the money go? Anthony and his wife Charlene lived lavishly. They maintained an apartment on Park Avenue. They traveled extensively. They purchased expensive artwork and antiques. Charlene bought designer clothing and jewelry, all funded by Brooke's fortune. Meanwhile, Brooke's own living conditions began to deteriorate. The isolation, 2003-2004. As Brooke's Alzheimer's progressed, Anthony began systematically isolating her from the friends and staff who'd been part of her life for decades. Alice Perdue, Brooke's social secretary for over 20 years, was fired in 2003. Alice had managed Brooke's busy social calendar, arranging luncheons, dinner parties, charity events, and visits from friends. She was beloved by Brooke and knew her preferences intimately. Anthony told Alice that Brooke was too confused to maintain her social schedule and didn't need a secretary anymore. Alice was devastated. When she went to say goodbye to Brooke, the elderly woman was confused and heartbroken. "But Alice," Brooke had said, tears in her eyes, "who will help me with my party?" Alice tried to explain, but Brooke couldn't understand why her longtime assistant was leaving. Chris Ely, Brooke's butler of 15 years, was fired in 2004. Chris had managed Brooke's household staff, maintained her apartment, and ensured she was comfortable. He was loyal, discreet, and devoted to Brooke. Anthony told Chris his services were no longer needed and that the household expenses needed to be reduced. Chris was replaced with cheaper, less experienced staff who rotated frequently and didn't know Brooke's routines or preferences. Annette de la Renta, wife of fashion designer Oscar de la Renta and one of Brooke's closest friends for over 40 years, found herself increasingly unable to visit or speak with Brooke. When Annette called, Anthony screened the calls. When she tried to visit, Anthony claimed Brooke was too tired or having a bad day. Eventually, Annette was told not to come at all because visits upset Brooke. Other friends, David Rockefeller Jr., socialites, artists, philanthropists, experienced the same treatment. Phone calls went unreturned. Visit requests were denied. Brooke, who'd once had one of the busiest social calendars in New York, became a recluse. Anthony's explanation was always the same. "Mother is too confused. Visitors upset her. I'm protecting her." But those who managed to see Brooke during this period told a different story. They said she seemed lonely, frightened, and desperate for company. She asked about friends she hadn't seen in months. She didn't understand why people had stopped visiting. She was being isolated, deliberately, systematically, by her own son. The living conditions, 2004-2006. Perhaps the most shocking aspect of Anthony's exploitation was the deterioration of Brooke's living environment. Brooke Astor lived at 778 Park Avenue, one of Manhattan's most prestigious addresses. Her apartment had once been impeccably maintained. Elegant furniture, priceless artwork, Persian rugs, fresh flowers delivered daily. But as Anthony took control, maintenance stopped. Minette Christie, one of Brooke's private nurses from 2003 to 2006, later testified about the conditions she witnessed. The carpets became torn and filthy, with sections completely worn through. Brooke's beloved dachshunds urinated and defecated on the floors, and the waste wasn't cleaned promptly. The smell was overwhelming. Furniture broke and wasn't repaired. Brooke sat in chairs with ripped upholstery and wobbly legs. The heating system malfunctioned, and Anthony refused to pay for repairs. During winter months, Brooke sat in her apartment wrapped in blankets, shivering in the cold. The apartment, once a showcase of elegance, became shabby and neglected. Pearline Noble, another nurse who worked for Brooke from 2004 to 2006, testified about Brooke's personal care. Brooke often wore the same nightgown for days because there was no one to help her change. She went days without bathing because Anthony said hiring someone to assist with bathing was too expensive. Her hair, once carefully styled weekly by a professional, became matted and unkempt. She developed bed sores from sitting in the same position for extended periods without being moved. When Noble complained to Anthony about these conditions, he dismissed her concern. "She's old," he said. "This is how old people live." But this wasn't how Brooke Astor should have lived. She had a fortune of over $100 million. She could have afforded the best care money could buy: round-the-clock nursing, physical therapy, a renovated apartment, any comfort she desired. Instead, she lived in squalor while her son lived in luxury. The will changes, 2003 to 2004. But Anthony's most brazen theft wasn't the money he took directly. It was the changes he made to Brooke's will. Brooke Astor's original will, drafted in the 1990s when she was still mentally sharp, reflected her lifelong values. The will divided her estate, estimated at $130, $150 million, as follows: a 65% to charitable organizations, the New York Public Library, the Metropolitan Museum of Art, the Bronx Zoo, the Animal Medical Center, and dozens of other institutions would receive substantial bequests. 25% to family members. Philip and his twin brother Alec would each receive approximately $10 $. Other family members would receive smaller bequests. 10-15% to close friends and staff. People who'd been loyal to Brooke for decades would receive gifts of artwork, jewelry, or cash. Anthony's share, approximately $15 $20 million plus continued income from a trust. This distribution reflected Brooke's belief that her fortune should primarily benefit the public, with reasonable provisions for family. But in 2003, Anthony arranged for a codicil, an amendment to the will that dramatically changed these provisions. The 2003 codicil reduced charitable bequests by approximately $30 million, increased Anthony's inheritance by $30 million. He gave Anthony's wife, Charlene, the right to live in one of Brooke's properties, rent-free for life, reduced Philip's and Alec's inheritances. Then, in 2004, Anthony arranged for a second codicil that made even more drastic changes, reduced charitable bequests by an additional $30 million, total reduction, $60 million, increased Anthony's inheritance by another $30 million, eliminated several bequests to friends and staff, and gave Anthony complete control over distributing Brooke's personal property, artwork, jewelry, furniture. Combined, these two codicils redirected approximately $60 billion from charities to Anthony and his wife. The question that would dominate the criminal trial was simple: did Brooke Astor actually want these changes? Or did Anthony manipulate a woman with Alzheimer's into signing documents she didn't understand? The circumstances surrounding the signings were deeply suspicious. According to testimony from Pearline Noble, on January 12, 2004, the day the second codicil was signed, Brooke was having a particularly bad day. She was confused, agitated, and didn't want to leave her bedroom. Anthony and Francis Morrissey, the estate lawyer who drafted the codicils, arrived at the apartment that afternoon. They needed Brooke's signature. Noble testified that Anthony literally pulled Brooke from her chair and dragged her into the living room while she protested. Morrissey laid documents on the table in front of her. "What am I signing?" Brooke asked, her voice weak and confused. "Just papers, Mother," Anthony said. "Just sign here." She signed. Not because she understood what she was signing. Not because she wanted to change her will. But because her son told her to. Noble was horrified. She reported the incident to her supervisor, but nothing was done. Anthony controlled Brooke's care, and complaining too loudly meant getting fired. Philip begins to suspect. 2005. Philip Marshall, Anthony's son and Brooke's grandson, had always been close to his grandmother. Throughout the 1980s and 1990s, he'd visited her regularly, attended family dinners, and maintained a loving relationship. But in the early 2000s, as Brooke's Alzheimer's progressed, Philip found it increasingly difficult to see her. His father made excuses. She's tired. She's not feeling well. She's too confused for visitors. When Philip did manage to visit, he was shocked by the changes. His grandmother, once vibrant and engaged, seemed lost and frightened. She barely recognized him. And her apartment, the elegant space he remembered from childhood, looked like it hadn't been cleaned in months. In 2005, Philip confronted his father. "Dad, what's going on? Grandma's living conditions are terrible. Why isn't she getting better care?" Anthony's response was dismissive. "You don't know what you're talking about. I'm taking care of her. She's fine." "She's not fine. The apartment is filthy. She looks neglected. If you don't like how I'm managing things, you can leave." The conversation ended there. But Philip couldn't shake his unease. In early 2006, Philip decided to make an unannounced visit to his grandmother's apartment. What he found horrified him. Brooke was sitting in a wheelchair in the living room, wearing a stained nightgown. Her hair was uncombed. There was dog feces on the floor. The apartment smelled of urine and decay. The nurse on duty, someone Philip had never met before, looked exhausted and overwhelmed. She told Philip that Brooke hadn't bathed in over a week because Mr. Marshall said it was too expensive to hire someone to help. Philip was stunned. His grandmother had over $100 million, and his father claimed it was too expensive to help her bathe? He looked at Brooke. She stared at him with vacant eyes, no recognition in her face. "Grandma," he said gently. "It's Philip, your grandson." She smiled vaguely, but said nothing. Philip left the apartment in tears. That night, he called his wife Nan and told her what he'd seen. "Someone has to do something," he said. "Dad is neglecting her. Or worse." "What are you going to do?" Nan asked. "I don't know yet, but I can't just stand by and watch this." Over the next few weeks, Philip consulted with friends, lawyers, and advocates for the elderly. They all said the same thing. If he suspected elder abuse, he needed to act. File a petition with the court. Seek guardianship. Force an investigation. But taking that step meant going to war with his own father. It meant potential public scandal. It meant family fractures that might never heal. Philip struggled with the decision. He loved his father. He didn't want to believe Anthony was capable of exploiting Brooke, but the evidence was undeniable. In July 2006, Philip made his decision. He hired a lawyer, Paul Saunders, an experienced estates and trusts attorney, and filed a petition in New York Supreme Court. The petition sought to remove Anthony Marshall as Brooke Astor's guardian and appoint Annette de la Renta in his place. The petition alleged elder abuse, financial exploitation, and gross neglect. The document was filed on July 24, 2006. The next day, the New York tabloids exploded with headlines. Astor family war. Grandson accuses father of abusing Brooke Astor. Battle for $100 million fortune. Philip's phone rang nonstop. Reporters, family members, curiosity seekers. His father left him a voicemail, his voice cold with fury. "You've made a terrible mistake," Anthony said. "You'll regret this." Philip's brother Alec called from Europe, shouting accusation. "How could you do this to Dad? You're destroying our family." Other relatives sided with Anthony. They accused Philip of being motivated by greed, of trying to seize control of Brooke's fortune, of betraying his father. But Philip stood firm. "This isn't about money," he told anyone who would listen. "This is about protecting Grandma." The legal battle had begun, and it would consume the next 3 years of Philip's life. The guardianship petition that Philip filed in July 2006 set off a chain reaction that would ultimately lead to criminal charges, a sensational trial, and Anthony Marshall's conviction. But in those early weeks, the outcome was far from certain. The court ordered evaluation, August-September 2006. When Philip's petition landed on the desk of Judge Eve Preminger of the New York Supreme Court, she immediately recognized the gravity of the allegations. This wasn't a routine family dispute over an inheritance. This was a potential case of elder abuse involving one of New York's most prominent citizens. Judge Preminger ordered an emergency evaluation of Brooke Astor's living conditions and mental state. She appointed Dr. Norman Relelkin, a prominent neurologist from Weill Cornell Medical College, to conduct a comprehensive medical examination. Dr. Relelkin visited Brooke's Park Avenue apartment on July 28, 2006, accompanied by a court-appointed social worker. What they found shocked them. Dr. Relelkin later testified about that visit in sworn deposition. When I entered Mrs. Astor's apartment, I was immediately struck by the poor condition of the premises. The carpets were torn and stained. The furniture was in disrepair. There was a strong odor of animal waste. The temperature in the apartment was uncomfortably warm, and I was told the air conditioning system wasn't working properly. Mrs. Astor was sitting in a wheelchair in the living room, wearing a nightgown. Her hair was uncombed. She appeared frail, underweight, and disoriented. When I introduced myself, she looked at me with confusion. She didn't understand why I was there or who had sent me. Dr. Relelkin conducted a series of cognitive tests, standard assessments used to evaluate dementia patients. The results were devastating. Brooke couldn't remember what year it was. She thought it was 1955. She couldn't name the current president. She couldn't recall her own address. When shown photographs of longtime friends, including Annette de la Renta, whom she'd known for over 40 years, she couldn't identify them. Mrs. Astor has advanced Alzheimer's disease, Dr. Relelkin concluded, in his report to the court. Her cognitive function is severely impaired. She is not competent to make decisions about her own care or finances. She requires a guardian immediately. The report was damning, but it got worse. Dr. Relelkin also documented physical signs of neglect. Brooke had lost approximately 20 pounds over the past year, suggesting inadequate nutrition. She had early-stage bed sores on her lower back and buttocks, indicating she wasn't being repositioned regularly. Her skin was dry and flaking, suggesting dehydration. Her fingernails and toenails were overgrown and yellowed. She had visible bruises on her arms of unknown origin. These findings are consistent with inadequate care, Dr. Relelkin wrote. Mrs. Astor is not receiving the level of medical attention and personal care that her condition requires and that her financial resources could easily provide. The social worker's report was equally disturbing. She interviewed the nurses and household staff and discovered staff turnover was extremely high. Nurses rarely lasted more than a few months because Anthony would fire them if they complained about conditions. The household budget had been slashed dramatically despite Brooke's vast wealth. Basic maintenance and repairs were being deferred indefinitely. Brooke's social isolation was severe. She had no visitors except medical personnel, and rarely left the apartment. Armed with these reports, Judge Preminger scheduled an emergency hearing for August 15, 2006. The emergency hearing, August 2006. The courtroom was packed for the August hearing. Reporters lined the walls. Anthony Marshall sat at the defense table with his attorney, Kenneth Warner. Philip sat on the opposite side with his lawyer, Paul Saunders. Annette de la Renta was present, as were several other of Brooke's longtime friends. Anthony's twin brother, Alec Marshall, flew in from Europe to support his father. He sat in the gallery, glaring at Philip. Judge Preminger entered and called the court to order. We're here on an emergency petition filed by Philip Marshall, seeking the removal of Anthony Marshall as guardian and power of attorney holder for Brooke Astor. I've reviewed Dr. Relelkin's report and the social worker's findings. Mr. Warner, does your client dispute these findings? Kenneth Warner stood. Your Honor, Mr. Marshall disputes the characterization of these findings. Yes, Mrs. Astor has Alzheimer's disease. Yes, she requires significant care. But Mr. Marshall has been providing that care to the best of his ability. The allegations of neglect are exaggerated and motivated by family animosity. Judge Preminger's expression was skeptical. Mr. Warner, Dr. Relkin found evidence of bed sores, malnutrition, and dehydration. The apartment was described as unsanitary. How is that providing adequate care? Your Honor, Mrs. Astor is 104 years old. She's frail. Some decline in her physical condition is inevitable regardless of the quality of care. Mr. Marshall has hired professional nurses. He's ensured she has medical attention. The apartment conditions are being addressed. Being addressed? Judge Preminger's tone was sharp. These conditions have existed for months, possibly years. Why weren't they addressed sooner? Warner hesitated. Your Honor, Mr. Marshall believed the conditions were acceptable. He relied on the nursing staff to alert him to any problem. And when they did alert him, he fired them. Isn't that correct? That's a mischaracterization, Your Honor. Paul Saunders, Philip's attorney, stood. Your Honor, may I speak? Please. Your Honor, the evidence is clear. Anthony Marshall has systematically neglected Brooke Astor while enriching himself from her estate. He's isolated her from friends who would have intervened. He's fired staff members who complained. And he's taken millions of dollars for himself while allowing her to live in squalor. This isn't a case of family animosity. This is a case of elder abuse. Your Honor, Warner interjected, these are inflammatory accusations without proof. The prosecution is painting Mr. Marshall as a villain, but he's actually a devoted son who's been caring for his mother for years. The real motivation here is Philip Marshall's desire to control his grandmother's fortune. Judge Preminger held up her hand. Gentlemen, I don't need to hear arguments about motivation. I need to make a decision about Mrs. Astor's welfare. And based on the evidence before me, I'm deeply concerned. She looked at Anthony Marshall directly. Mr. Marshall, I'm removing you as your mother's guardian effective immediately. I'm appointing Annette de la Renta as emergency guardian, and I'm ordering a full investigation into your management of your mother's finances. If wrongdoing is found, I'll refer this matter to the district attorney's office for potential criminal prosecution. The courtroom erupted. Reporters rushed for the doors. Anthony's face flushed with anger. Alex stood and shouted, "This is a travesty." Judge Preminger banged her gavel. Order! This hearing is adjourned. Philip felt a wave of relief wash over him. His grandmother would finally get the care she needed. But the battle was far from over. Annette de la Renta takes over, September 2006. Annette de la Renta was 64 years old, elegant, multilingual, and fiercely devoted to her friend, Brooke. When Judge Preminger appointed her as guardian, Annette accepted immediately. Brooke was like a sister to me, she told reporters outside the courthouse. I'll do everything in my power to ensure she receives the care and dignity she deserves. Annette's first action was to visit Brooke's apartment. What she found brought her to tears. I couldn't believe it, she later testified. This was the home of a woman who'd lived with such elegance, such style. And it had been allowed to deteriorate into this nightmare. Annette immediately took action. She hired a team of professional cleaners to deep clean the entire apartment. She replaced all the torn carpets and repaired broken furniture. She fixed the heating and air conditioning systems. She hired additional nursing staff, round-the-clock care from experienced, compassionate professionals. She arranged for a physical therapist to work with Brooke daily. She had Brooke examined by specialists to address her malnutrition, dehydration, and bed sores. She invited Brooke's friends to visit regularly. The transformation was remarkable. Within weeks, Brooke looked healthier. She'd gained weight. Her bed sores healed. Her hair was professionally styled. She wore clean, comfortable clothing. Annette also began reviewing Brooke's financial records, and what she discovered was even more disturbing than the living conditions. The forensic accounting investigation, October 26, February 2007. Annette hired a forensic accounting firm, Berkowitz, Dick, Pollock & Brandt, to conduct a comprehensive audit of Brooke's finances under Anthony's management. The forensic accountants, led by partner Robert Brennan, spent 4 months analyzing bank statements, wire transfers, checks, investment records, property sales, and estate planning documents. Their findings, released in a 247-page report in February 2007, painted a devastating picture of financial exploitation. Key findings. 1. Anthony's income from Brooke's estate had increased 900% after receiving power of attorney. A from 1995 to 21, before power of attorney, averaged $200,000 a year. A from 2002 to 2006, after power of attorney, averaged $1.80 million a year. I total received 2002-2006, approximately $9 million. 2. The codicils diverted $60 million from charities to Anthony. The report documented how the 2003 and 2004 codicils had dramatically altered Brooke's estate plan. Original will, drafted 1997. Anthony's inheritance, HE, $15 million. Charities, HH, $95 billion. After 2003 codicil, Anthony's inheritance, HE, $30 billion. Charities, HHA, $75 million. After 2004 codicil, Anthony's inheritance, HE, $65 million. Charities, Shech, Tate, $35 million. The accountants found no documentation of Brooke requesting these changes. No letters. No emails. No witnesses except Francis Morrissey, who drafted the codicils and stood to earn substantial fees from Anthony's increased inheritance. 3. The Child Hassam painting sale was suspicious. In 2002, Anthony sold Brooke's prized Child Hassam painting, Flags, Fifth Avenue, for approximately $10 at Sotheby's auction. The painting had hung in Brooke's living room for decades. She'd told friends countless times that she never wanted to sell it. It reminded her of Vincent Astor, her late husband. But in 2002, shortly after Anthony received power of attorney, the painting was suddenly put up for auction. The $10 million in proceeds went into Brooke's account. But within weeks, $8 million of that money was transferred to a separate account controlled by Anthony. Anthony's explanation: "Mother wanted me to have it as a gift." The forensic accountants found no evidence that Brooke had requested this gift. And by 2002, she was already showing significant cognitive impairment. 4. The Cove End sale was below market value and suspicious. Cove End was Brooke's beloved summer estate in Northeast Harbor, Maine. She'd owned the property for over 40 years and spent every summer there until the late 1990s. The property was appraised in 2003 at approximately $2.3 million. In 2004, Anthony sold it for $1 billion, at least $1 million below market value. The buyer was Charlene Marshall, no relation to Anthony's family, but a close friend of Anthony's wife, also named Charlene. And here's where it got really suspicious. Charlene Marshall, the buyer, had executed a will shortly after purchasing Cove End that left the property to Anthony's wife, Charlene Marshall, the seller's daughter-in-law, upon her death. In other words, Anthony sold his mother's property for $1 million below market value. To a friend of his wife, who promised to leave the property to Anthony's wife in her will. The forensic accountants concluded this was a sham sale designed to transfer Brooke's property to Anthony's family at a fraction of its true value. 5. Household expenses were slashed while Anthony's living expenses soared. From 2002 to 2006, Brooke's household expenses dropped from $600,000 a year to $400,000 a year, a 33% decrease. Anthony's personal expenses increased from $150,000 a year to $650,000 a year, a 333% increase. While Brooke lived with broken furniture and torn carpets, Anthony and his wife Charlene purchased a yacht, bought expensive artwork and antiques. They traveled extensively, first-class flights, luxury hotels, hired a private chef, and renovated their Park Avenue apartment, all funded by Brooke's money. The report's conclusion. Robert Brennan's executive summary was blunt. Our investigation has uncovered systematic financial exploitation of Brooke Astor by her son, Anthony Marshall. Mr. Marshall used his position as power of attorney to enrich himself at his mother's expense. He changed her will to divert tens of millions of dollars from charitable organizations to himself. He sold her property below market value in transactions that benefited his family. He increased his own compensation. In our professional opinion, Mr. Marshall's conduct constitutes criminal financial exploitation of a vulnerable elderly person. We recommend that this matter be referred to law enforcement for investigation and potential prosecution. The district attorney gets involved. March 2007. When Annette de la Renta received the forensic accounting report, she immediately forwarded it to the Manhattan District Attorney's office. District Attorney Robert Morgenthau, legendary prosecutor, and Manhattan since 1975, assigned the case to his Elder Abuse Unit, a specialized team of prosecutors who handled crimes against the elderly. Assistant District Attorney Joel J. Seidemann was assigned as lead prosecutor. He was in his early 40s, a methodical, detail-oriented lawyer with a track record of successful prosecutions in complex financial cases. Seidemann's co-counsel was Elizabeth Louie, a younger prosecutor known for her aggressive courtroom style. Together, they spent 3 months investigating Anthony Marshall. They interviewed nurses, household staff, friends of Brooke, financial advisors, attorneys, and Philip Marshall. They subpoenaed bank records, wire transfer logs, emails, and phone records. They consulted with medical experts about Brooke's mental capacity during the critical 2003-2004 period when the codicils were signed. By June 2007, they'd built what they believed was an airtight case. But before they could file charges, tragedy struck. Brooke Astor dies, August 13, 2007. On the morning of August 13, 2007, Brooke Astor died at her Park Avenue apartment. She was 105 years old. She'd been under Annette de la Renta's care for the past year, and by all accounts, that final year had been peaceful. Her living conditions had been restored to elegance. She'd received excellent medical care. Her friends had visited regularly, but by the end, Brooke didn't know where she was. She didn't recognize anyone. The Alzheimer's had taken everything. Annette was with her when she passed. She died peacefully, Annette told reporters. She was surrounded by people who loved her. The funeral was held at St. Thomas Church on Fifth Avenue. Hundreds attended: politicians, philanthropists, artists, society figures. Mayor Michael Bloomberg delivered a eulogy. David Rockefeller spoke. Annette spoke. Anthony Marshall attended, sitting in a back pew with his wife Charlene. Philip sat in the front with Annette and other family friends. Father and son did not speak to each other. After the funeral, Philip stood outside the church and spoke to reporters. "My grandmother was an extraordinary woman," he said, his voice thick with emotion. "She gave so much to this city. In her final years, she deserved better than what she got. I'm grateful that Annette was able to give her a peaceful final year, but I'll never forgive the years of neglect that came before." A reporter shouted a question. "Do you think your father should be prosecuted?" Philip paused. "That's for the district attorney to decide. But I believe there should be accountability for what happened to my grandmother." 3 months later, the DA's office announced its decision. Criminal charges filed, November 2007. On November 2, 2007, a grand jury in Manhattan returned an indictment against Anthony Dryden Marshall and Francis X. Morrissey, Jr. The charges: against Anthony Marshall, 16 counts, grand larceny in the first degree, theft over $1 million, grand larceny in the second degree, theft over $50,000, conspiracy in the fourth degree, criminal possession of stolen property in the first degree, scheming to defraud in the first degree, forgery in the second degree, multiple counts, falsifying business records. Against Francis Morrissey, 6 counts, conspiracy in the fourth degree, scheming to defraud in the first degree, forgery in the second degree, multiple counts. The indictment alleged that Anthony had stolen approximately $60 from his mother through fraudulent codicils, the Child Hassan painting sale, the Covent property sale, and various other transfers. It alleged that Francis Morrissey had assisted in the scheme by drafting the fraudulent codicils and witnessing Brooke's signature, despite knowing she was mentally incompetent. At a press conference, Robert Morgenthau was unusually blunt. Brooke Astor was one of New York's greatest philanthropists, he said. She gave away nearly $200 million to make this city a better place. In her final years, when she was vulnerable and suffering from Alzheimer's disease, her own son stole from her. Today, we're holding him accountable. Joel Seidemann added, "This case sends a message that elder abuse will not be tolerated in Manhattan, not even when the perpetrator is the son of a legendary philanthropist, and not even when the victim has already passed away. Justice delayed is not justice denied." Anthony Marshall was arrested at his Park Avenue apartment the next morning. He was photographed being led out in handcuffs, a humiliating perp walk that made the front page of every New York tabloid. The headlines were brutal. Astor disaster. Son arrested for stealing $60 from dying mom, New York Post. Brooke Astor's son charged with grand larceny, New York Times. And the ultimate betrayal. How Anthony Marshall robbed his mother blind, Daily News. Anthony was arraigned that afternoon. He pleaded not guilty to all charges. Bail was set at $100,000, which he posted immediately. Francis Morrissey was also arrested and arraigned. He pleaded not guilty and posted bail. Both men were ordered to surrender their passports and remain in New York pending trial. The trial date was set for March 30, 2009, 16 months away. The family fractures deepen, 28. The period between the indictment and the trial was excruciating for Philip. His father, out on bail, gave interviews claiming innocence. "I loved my mother," Anthony told Barbara Walters in a televised interview. "I would never have hurt her. My son has destroyed our family for money." Philip's brother Alec appeared on the same program, sitting beside his father. "Philip has always been jealous of Dad," Alec said. "This whole thing is motivated by greed. Philip wanted control of Grandma's money, and when he didn't get it, he went to the authority." Philip was devastated by these accusations. He gave his own interviews defending his actions. "This was never about money," he told Anderson Cooper on CNN. "I filed that guardianship petition because my grandmother was being neglected. I cooperated with prosecutors because my father committed crimes. If that makes me the villain in my family's eyes, so be it. I can live with that. What I couldn't live with was standing by and doing nothing." Other family members took sides. Some supported Philip, praising his courage for standing up to his father. Others sided with Anthony, accusing Philip of being vindictive and opportunistic. Thanksgiving 2008 was the first in Philip's life without extended family. His father wasn't speaking to him. His brother wasn't speaking to him. Half his cousins weren't speaking to him. He spent the holiday with Nan and their sons, trying to find gratitude amid the wreckage of his family. "Do you regret it?" Nan asked him that night. "Every day," Philip admitted, "but I'd do it again, because it was the right thing to do." As 2008 turned to 2009, the trial date approached. Philip knew he'd have to testify against his father. He'd have to sit in a courtroom and recount, in detail, how Anthony had exploited Brooke. And he'd have to do it knowing that half his family would hate him for it. But there was no turning back now. Justice for Brooke Astor demanded it. March 30, 2009. The first day of jury selection. The case was formally titled People of the State of New York Wythe, Anthony D. Marshall, and Francis X. Morrissey, Jr., Case No. 6303 2007, assigned to Judge A. Kirk Bartley, Jr. of the New York County Supreme Court. Judge Bartley was a veteran of the bench, 63 years old, with silver hair, wire-rimmed glasses, and a reputation for running a tight, efficient courtroom. He'd presided over numerous high-profile trials during his 28 years as a judge, and was known for his patience with juries, but zero tolerance for grandstanding attorneys. The courtroom was packed from day one. The trial had everything the media loved: wealth, family betrayal, a legendary victim, and accusations of elder abuse against the backdrop of New York high society. The prosecution team, Joel Seidemann and Elizabeth Louie, sat at the table closest to the jury box, surrounded by bankers' boxes full of financial records, medical reports, and witness statements. The defense team was equally formidable. Anthony Marshall's lead attorney was Kenneth Warner, a prominent criminal defense lawyer in his 60s, with silver hair and a polished professorial demeanor. Warner had successfully defended numerous white-collar defendants and specialized in complex financial crime cases. Francis Morrissey was represented by Michael Ross, a younger attorney known for his aggressive cross-examination style. Anthony Marshall sat at the defense table wearing a dark suit and tie. At 85 years old, he looked frail, walking with a cane. But his expression was resolute, the expression of a man who believed he'd done nothing wrong. Francis Morrissey, sitting beside him, looked nervous. At 68, Morrissey had been a successful estate planning attorney for decades. Now he faced the prospect of prison time for fraud and forgery. Philip Marshall sat in the second row of the gallery with his wife Nan Data. Across the aisle, separated by an invisible wall of animosity, sat Alec Marshall, who'd flown in from Europe to support his father. The brothers didn't acknowledge each other. Jury selection, March 30, April 13, 2009. Jury selection took 2 weeks, longer than typical, but unsurprising given the case's high profile and complexity. The judge and attorneys questioned hundreds of potential jurors, looking for 12 individuals who could be fair and impartial, despite extensive media coverage of the Astor case. Many potential jurors were dismissed during voir dire for various reasons. Some had already formed strong opinions about the case from news coverage. Some had personal experiences with elder abuse, either as victims, witnesses, or perpetrators, that might bias them. Some worked in finance or estate planning and might have conflicts of interest. Some admitted they couldn't imagine convicting an 85-year-old man regardless of the evidence. The defense used its peremptory challenges to strike jurors who seemed too sympathetic to the prosecution, particularly younger jurors, women with elderly parents, and anyone who worked in healthcare or social services. The prosecution struck jurors who seemed too sympathetic to the defense, particularly older, wealthier jurors who might relate to Anthony Marshall, and anyone who expressed skepticism about family disputes ending up in criminal court. By April 13, 2009, they had their jury, 8 women and 4 men, plus 2 alternates. The jurors ranged in age from late 30s to late 60s. They included a retired teacher, an accountant, a small business owner, a postal worker, a nurse, not dismissed because she'd never worked in elder care, a librarian, an IT consultant, and several others from diverse professional backgrounds. None of them knew Brooke Astor personally. None of them moved in high society circles. They were ordinary New Yorkers tasked with judging an extraordinary case. Opening statements, April 14, 2009. The courtroom was standing room only on April 14. Every journalist in New York seemed to be there. Court sketch artists sat in the front row, their hands moving rapidly across their pads. Philip sat with Nan, his stomach churning with anxiety. This was it, the moment they'd been building toward for nearly 3 years. Judge Bartley called the court to order and addressed the jury. Ladies and gentlemen, you've been selected to serve on this jury. Over the next several months, you'll hear evidence about alleged crimes committed against Brooke Astor, a prominent New York philanthropist who died in 2007. The defendants are Anthony Marshall, her son, and Francis Morrissey, her attorney. You are about to hear opening statements from both sides. These statements are not evidence. They are the attorney's previews of what they believe the evidence will show. You will base your verdict solely on the evidence presented during the trial, not on the opening statements. He nodded to Joel Seidemann. Mr. Seidemann, you may proceed with the people's opening statement. The prosecution's opening statement. Joel Seidemann rose and approached the jury box. He spoke without notes, his voice calm and conversational. Good morning, ladies and gentlemen. My name is Joel Seidemann, and I represent the people of the state of New York. He paused, making eye contact with each juror. Over the next several months, you're going to hear a story that's difficult to hear. It's a story about betrayal, about greed, about a son who looked at his dying mother and saw not a person who needed his care, but a fortune he wanted to control. Brooke Astor was one of the most remarkable women in New York City history. She wasn't born wealthy. She married into the Astor fortune in 1953, when she wed Vincent Astor, one of the richest men in America. When Vincent died in 1959, he left Brooke control of his fortune, approximately $67 million. Brooke could have lived a life of leisure. She could have spent that money on herself, on travel, art, jewelry, luxury. But that's not who she was. Sideman walked to a display board where a photograph of Brooke, elegant, smiling, radiant, had been mounted. Instead, Brooke Astor spent the next 50 years giving that fortune away. She funded the New York Public Library, the Metropolitan Museum, the Bronx Zoo, parks, schools, housing projects, cultural institutions. She gave away nearly $200 million because she believed wealth was a responsibility, not a privilege. She was beloved. She was admired. She was New York royalty. Sideman's tone darkened. But in 2000, Brooke began showing signs of Alzheimer's disease. Her memory started failing. She became confused, disoriented. By 2002, she had advanced dementia. She couldn't remember conversations. She didn't recognize longtime friends. She was losing herself. And during those years, while Brooke's mind was deteriorating, her son, the defendant Anthony Marshall, was stealing her fortune. He turned and pointed at Anthony. Anthony sat motionless, his expression blank. The evidence will show that Anthony Marshall systematically exploited his mother's dementia to enrich himself. He used his position as her power of attorney to drain millions from her account. He changed her will twice to reduce charitable bequests by 60 million yen and increase his own inheritance. He sold her priceless artwork and pocketed the proceeds. He sold her beloved summer home for $1 billion below market value to a friend who promised to leave it to his wife. Don't know why. And while he was doing all of this, while he was stealing millions, Brooke Astor, one of the greatest philanthropists in American history, was living in squalor. Sideman's voice rose with emotion. The evidence will show that Brooke's Park Avenue apartment, once a showcase of elegance, became filthy and neglected under Anthony Marshall's care. Torn carpets, broken furniture, dog feces on the floors, no heat in the winter. Brooke sat in a wheelchair, wrapped in blankets, shivering in her own home. You'll hear from nurses who witnessed Anthony Marshall drag his mother from her bedroom to sign documents she didn't understand. You'll hear from friends who visit Brooke, but were turned away by Anthony because he was isolating her, cutting her off from anyone who might question what he was doing. You'll hear from forensic accountants who traced the money, $9 million that flowed from Brooke's accounts to Anthony's between 2002 and 2006. You'll hear from handwriting experts who'll testify that Brooke's signature on fraudulent codicils to her will was forged or signed under duress. You'll hear from doctors who'll testify that by 2003, Brooke was mentally incompetent, unable to understand complex legal documents, unable to make informed decisions about her estate. Sideman walked back toward the prosecution table, then turned to face the jury one more time. Ladies and gentlemen, this case is about elder abuse. It's about a vulnerable woman with dementia being exploited by the person she trusted most, her own son. Anthony Marshall didn't care for his mother. He cared about her money, and he took it. Methodically, deliberately, criminally. At the end of this trial, we'll ask you to hold him accountable. We'll ask you to find him guilty of grand larceny, conspiracy, and fraud. Brooke Astor can't speak for herself anymore, but through your verdict you can speak for her. You can deliver justice. Thank you. And Sideman sat down. The courtroom was silent. Several jurors were visibly emotional. Philip felt tears prick his eyes. Sideman had captured everything. The betrayal, the exploitation, the heartbreak. Now, it was the defense's turn. The defense's opening statement. Kenneth Warner stood, buttoning his suit jacket. He walked slowly toward the jury box, his expression grave but sympathetic. Ladies and gentlemen, he began, his voice warm and measured, you've just heard Mr. Sideman's version of this case. And I'm not going to stand here and tell you that Brooke Astor didn't suffer in her final years. She did. Alzheimer's disease is cruel. It robs people of their memories, their dignity, their very sense of self. But this case isn't about whether Brooke Astor had Alzheimer's. It's about whether Anthony Marshall committed crimes. And the evidence, the actual evidence, not the prosecution's emotional narrative, will show that he did not. Warner gestured toward Anthony. Anthony Marshall is 85 years old. He's a decorated World War II veteran who served his country in the Pacific Theater. He's been married to the same woman for over 30 years. He's a father and grandfather. And yes, he was Brooke Astor's son. A son who loved his mother. A son who cared for her as she aged. A son who managed her affairs faithfully for years. Warner's tone was reasonable, almost conversational, a stark contrast to Seideman's passionate delivery. The prosecution wants you to believe that Anthony Marshall was a monster, that he saw his mother as nothing more than a source of money. But the evidence will tell a different story. You'll hear that Brooke gave Anthony power of attorney willingly. She trusted him. She wanted him to manage her finances. And he did, responsibly, for years. You'll hear that the changes to Brooke's will were made at her request. Yes, she had Alzheimer's, but Alzheimer's patients don't become completely incompetent overnight. They have lucid moments. They have lucid moments. They have lucid moments. They have preference was to provide for her son, the son who'd been by her side for decades. Warner walked toward the exhibit board and gestured to the photograph of Brooke. Mr. Seideman showed you a beautiful picture of Brooke Astor in her prime. But he's asking you to ignore reality. The reality is that Brooke was 105 years old when she died. She'd been battling Alzheimer's for years. No amount of money or care could have prevented her decline. The prosecution will show you photos of Brooke in her final years and ask you to feel sorry for her. And you should. But feeling sorry for her doesn't mean Anthony Marshall committed crimes. The prosecution says Anthony stole money from his mother. But every dollar Anthony received was either a gift Brooke gave him or compensation for years of managing her complex financial affairs. There was no theft. The prosecution says Anthony changed Brooke's will to benefit himself, but Brooke signed those codicils willingly. She was examined by doctors who found her competent. She understood what she was doing. The prosecution says Anthony sold Brooke's property below market value, but real estate valuations are subjective, and Brooke approved those sales. Warner paused, looking each juror in the eye. Ladies and gentlemen, the prosecution has the burden of proof in this case. They must prove, beyond a reasonable doubt, that Anthony Marshall committed these crimes. And when you examine the evidence carefully, not emotionally, but rationally, you'll see that they can't meet that burden. Because this isn't a criminal case. It's a family dispute that should never have ended up in a courtroom. It's a grandson, Philip Marshall, who disagreed with his father's decisions and went to the authorities. A grandson who wanted control of his grandmother's estate. Philip felt his jaw clench. Warner was making him the villain. The prosecution will parade witness after witness who'll tell sad stories about Brooke's decline. But decline is not the same as abuse. And disagreement about care decisions is not the same as criminal neglect. When you've heard all the evidence, when you've seen beyond the prosecution's emotional appeals to the actual facts, I'm confident you'll reach the only fair verdict. Not guilty. Anthony Marshall loved his mother. He cared for her. And he doesn't deserve to spend his final years in prison for crimes he didn't commit. Thank you. Warner sat down. Judge Bartley addressed the jury. Ladies and gentlemen, you've now heard opening statements from both sides. Tomorrow, the prosecution will begin presenting its case. We'll recess until 9:00 a.m. Remember, do not discuss this case with anyone. The jury filed out. The spectators began gathering their belongings. Philip stood, his legs unsteady. Nan squeezed his hand. You okay? No, Philip admitted. But I will be. We have the evidence. The truth is on our side. And if the jury doesn't believe it? Philip looked across the aisle at his father, who was being helped to his feet by Kenneth Warner. Anthony's eyes met Philip's for a brief moment. Cold, hard, unforgiving. They have to believe it, Philip said quietly. Because if they don't, Everything I've sacrificed was for nothing. The trial was underway. And over the next 4 months, 12 strangers would decide whether Philip had been a hero or a traitor, whether his father was a criminal or a victim of false accusations, whether justice for Brooke Astor was still possible, even after her death. The prosecution's case began on April 15, 29, and would stretch across 3 months of testimony. Joel Seidman and Elizabeth Lowy called over 70 witnesses, introduced hundreds of exhibits, and methodically built a case that painted Anthony Marshall as a calculating thief who'd exploited his mother's dementia for personal gain. Philip attended every day of testimony. He took notes. He watched the jury's reactions, and he listened as strangers described things he'd witnessed but hadn't fully understood until now. Week 1-2. The medical witnesses. April 15, 28, 2009. The prosecution's strategy was simple. Establish that Brooke Astor had severe Alzheimer's disease that rendered her incompetent to make financial decisions by 2003-2004, the period when the fraudulent codicils were signed. Dr. Howard Phillott, the Alzheimer's specialist. Dr. Phillott was the first medical witness. He was a distinguished geriatrician in his 60s, with graying hair and a calm, professorial manner. He'd been treating Brooke Astor since 2000. Seidman walked him through his credentials: medical degree from Mount Sinai, fellowship in geriatric medicine, nationally recognized expert on Alzheimer's disease, author of numerous peer-reviewed papers. Dr. Phillott, when did you first examine Brooke Astor? In March 2000, she was 98 years old. Her primary care physician had referred her to me because of memory complaints. What did you find? I conducted a comprehensive cognitive assessment. Mrs. Astor scored 24 out of 30 on the mini mental state examination, a standard test for dementia. Scores below 24 indicate cognitive impairment. She was borderline. Did you make a diagnosis? Not initially. Some cognitive decline is normal with aging. I recommended follow-up in 6 months. And what did you find during that follow-up? Her score had dropped to 21. She was having increasing difficulty with short-term memory, problem-solving, and judgment. I diagnosed her with mild cognitive impairment, likely early-stage Alzheimer's disease. How did her condition progress? I saw her every 6 months through 2004. Each time she declined further. By 2002, she scored 18 on the MMMC. By 2004, she scored 12. That's moderate to severe dementia. Dr. Phillott, can you explain to the jury what those scores mean in practical terms? Certainly. At a score of 21, a patient might forget recent conversations, struggle with complex tasks like managing finances, and have difficulty following multi-step instructions. At a score of 12, a patient typically can't remember what day it is, doesn't recognize familiar faces, and has virtually no capacity to understand complex legal. Seidman displayed Brooke's MMSE scores on a chart for the jury. March 2024, September 2021, March 2001, 19, September 2001, 18, March 2002, 17, again, September 2002, 16, on March 2003, 14, September 2003, 13, on March 2004, 12. The steady decline was undeniable. Dr. Phillott, the codicils to Mrs. Astor's will were signed in January 2003 and March 2004. Based on her cognitive state at those times, was she competent to understand complex legal documents? Absolutely not. At those cognitive levels, Mrs. Astor could not have comprehended the legal and financial implications of changing her will. Kenneth Warner's cross-examination focused on the variability of Alzheimer's symptoms. Dr. Phillott, isn't it true that Alzheimer's patients can have good days and bad days? Yes, there's fluctuation. So it's possible that on January 15, 2003, the day the first codicil was signed, Mrs. Astor might have been having a particularly good day. It's theoretically possible, but unlikely given the severity of her impairment. But you can't rule it out. I can't rule out any possibility with absolute certainty. but the probability that someone with an MES score of 14 would have sufficient lucidity to understand estate planning documents is extremely low. But not zero. Not zero, but close to it. Thank you, Doctor. No further questions. It was a small victory for the defense, creating doubt about whether Brooke was always incompetent. But the damage was done. The jury had seen the steady cognitive decline. Dr. Norman Relelkin, the court-appointed neurologist. Dr. Relelkin was the neurologist who'd examined Brooke in July 2006 at the court's request during Philip's guardianship petition. His testimony was devastating. Dr. Relelkin, please describe your examination of Mrs. Astor in July 2006. I conducted a comprehensive neurological and cognitive evaluation at her Park Avenue apartment. Mrs. Astor was 104 years old at the time. What did you find? She was profoundly impaired. She couldn't tell me what year it was. She thought it was 1955. She couldn't name the current president. She didn't know her own address. When I showed her photographs of people she'd known for decades, she couldn't identify them. Did you test her cognitive function? Yes. She scored 6 out of 30 on the MMSE. That's severe dementia, consistent with advanced Alzheimer's disease. In your medical opinion, was Mrs. Astor competent to make decisions about her own care or finances in 2006? Absolutely not. She required a guardian immediately. Dr. Relelkin, based on her trajectory of decline, do you have an opinion about her competency in 2003 and 2004? Objection. Warner stood. Calls for speculation. Your Honor, Siedemann argued. Dr. Relelkin is testifying as an expert. Experts are permitted to give opinions based on their professional judgment. I'll allow it, Judge Bartley ruled. But make clear it's an opinion. Dr. Relelkin, in your professional opinion, based on the progression of Mrs. Astor's disease, would she have been competent to understand complex legal documents in 2003 and 2004? No. Based on the documented cognitive decline from 2000 through 2006, and based on typical Alzheimer's progression, Mrs. Astor would not have had capacity to understand estate planning documents in 2003 or 2004. Warner's cross-examination attacked Dr. Relelkin's credibility. Dr. Relelkin, you were hired by Philip Marshall, the man suing his father, correct? I was retained by the court at Mr. Marshall's petition, yes. And you were paid for your testimony? I was paid for my professional services, as is standard. And you knew your testimony would be used to remove Anthony Marshall as guardian? I knew my medical findings would be submitted to the court. My job was to evaluate the patient, not to take sides in a family dispute. But your evaluation benefited Philip Marshall's case, didn't it? My evaluation reflected Mrs. Astor's medical condition. If that benefited anyone's case, it's because the medical facts supported their position. Of course, Warner said, his tone dripping with skepticism. No further question. Dr. Prasad Kilaru, the psychiatrist. Dr. Kilaru was a psychiatrist who'd evaluated Brooke in 2005 after staff members expressed concerns about her mental state. His testimony corroborated the other doctors' findings. Mrs. Astor exhibited severe cognitive impairment, paranoid ideation, and complete disorientation. She asked me repeatedly where her mother was, not understanding that her mother had been dead for decades. She became agitated when I tried to explain. She was living in a different time period entirely. By the end of the second week, the prosecution had established beyond doubt that Brooke Astor had severe, progressive Alzheimer's disease that destroyed her capacity to make informed decisions about her estate. Week 3-5. The caregivers and household staff, May 22, 2009. Next came the witnesses who'd seen Brooke's living conditions firsthand, the nurses, household staff, and caregivers who'd worked in the Park Avenue apartment. Minette Christie, private nurse, 2003-2006. Minette Christie was a Jamaican-born nurse in her mid-50s with over 20 years of experience in elder care. She'd worked for Brooke from August 2003 until she was fired by Anthony in June 2006. Her testimony was heartbreaking. Miss Christie Please describe Mrs. Astor's apartment when you first started working there in 23-12. It was beautiful. Elegant furniture, artwork on the walls, fresh flowers delivered every week. Everything was clean and well maintained. Mrs. Astor still had moments of lucidity back then. She'd tell me stories about parties she'd hosted, famous people she'd met. What happened over time? Minette's voice became pain. It deteriorated. Slowly at first, then rapidly. By 2005, the apartment was falling apart. Can you be specific? The carpets, they were expensive Persian rugs, became torn and stained. Mrs. Astor's dogs would have accidents, and no one cleaned them up right away because Mr. Marshall said we couldn't hire additional cleaning staff. He said it was too expensive. What else? The furniture broke. A chair Mrs. Astor liked to sit in had a wobbly leg. I reported it to Mr. Marshall multiple times. He never fixed it. Eventually, Mrs. Astor fell out of that chair. She wasn't seriously hurt, but she could have been. Tell the jury about the heating situation. Minette's eyes welled with tears. In the winter of 2005-2006, the heating system wasn't working properly. The apartment was freezing. Mrs. Astor would sit in her wheelchair wrapped in blankets, shivering. I called Mr. Marshall and told him his mother was cold. He said, "Put more blankets on her." Did he fix the heating? Not for weeks. Eventually, after I threatened to call Adult Protective Services, he had someone come look at it. But Mrs. Astor spent weeks in the cold. Miss Christie, did you observe Mr. Marshall's behavior toward his mother? Yes. He visited maybe once a week, sometimes less. When he came, he barely spoke to her. He'd talk to me about bills and expenses, always complaining that things cost too much. Then he'd leave. Did Mrs. Astor ever ask about him? All the time. She'd say, "Where's Anthony? Why doesn't he visit?" It broke my heart. She didn't understand that he was the one keeping people away from her. Why were you fired in June 2006? I complained too much. I told Mr. Marshall his mother needed better care, more nursing hours, physical therapy, repairs to the apartment. He said I was causing problems and terminated me. Kenneth Warner's cross-examination tried to suggest Minette was a disgruntled employee with an axe to grind. Miss Christie, you were angry about being fired, weren't you? I was upset, yes. But I was more upset about Mrs. Astor's treatment. You were granted immunity from prosecution in exchange for your testimony, correct? Yes. So you have a motive to exaggerate or lie to please the prosecution. Minette's voice was firm. I'm not lying. I saw what I saw. Mrs. Astor deserved better than what she got, and I'm telling the truth about that, whether I have immunity or not. Pearline Noble, private nurse, 2004-2006. Pearline Noble was another nurse who'd worked for Brooke. Her testimony about the codicil signing was explosive. Ms. Noble, were you present at Mrs. Astor's apartment on January 15, 2003? Yes. What happened that day? Mr. Marshall and another man, I later learned he was Mr. Morrissey, a lawyer, came to the apartment around 2:00 p.m. They said they needed Mrs. Astor to sign some papers. What was Mrs. Astor's condition that day? She was having a bad day. She was confused, agitated. She didn't want to leave her bedroom. She kept saying, "I'm tired. I want to rest." What did Mr. Marshall do? Pearline's expression hardened. He pulled her out of her chair. He grabbed her arms and pulled her to her feet. She was crying, saying, "Stop, Anthony. I don't want to." But he dragged her into the living room anyway. Did Mrs. Astor resist? She tried to, but she was too frail. He was much stronger than her. What happened next? Mr. Morrissey put papers on the table in front of her. He said, "Mrs. Astor, you need to sign these documents." She looked at them, confused. She asked, "What are these?" Mr. Marshall said, "Just papers, Mother. Just sign here." He pointed to a line. Did Mrs. Astor read the documents? No, she couldn't. Her eyesight was poor, and even if she could see them, I don't think she could have understood them. She just signed where they told her to sign. How long did the signing take? maybe 5 minutes. Then Mr. Marshall and Mr. Morrissey left. Mrs. Astor was upset for the rest of the day. She kept asking me, "What did I sign? What did I sign?" I didn't know what to tell her. Warner's cross-examination was aggressive. "Ms. Noble, you were also fired by Mr. Marshall, weren't you?" "Yes, in early 2006. So you also have a grudge against him?" "I have a problem with how he treated his mother." "That's not a grudge. That's a moral objection." "But you've been granted immunity too, haven't you?" "Yes." "So you benefit from testifying against Mr. Marshall?" "I benefit from telling the truth. Whether that helps the prosecution or not isn't my concern." "Ms. Noble, you testified that Mr. Marshall dragged his mother to the living room. That's a very dramatic word. Isn't it possible he was simply helping her walk?" "I know the difference between helping someone walk and dragging them. He dragged her." "But you weren't taking notes at the time, were you? You're testifying from memory about events that happened 6 years ago? Some things you don't forget?" I'll never forget the look on Mrs. Astor's face that day. She was frightened, and her own son was the one frightening her. Chris Ely, butler, 1992 to 24. Chris Ely had been Brooke's butler for 12 years before being fired by Anthony in 2004. His testimony focused on the systematic cost-cutting that occurred under Anthony's management. "Mr. Ely, what were your responsibilities as Mrs. Astor's butler?" "I managed the household staff, coordinated meals, maintained the apartment, handled correspondence, arranged flowers, whatever Mrs. Astor needed." "How many staff members were there when you started in 1992? 5 full-time employees. Myself, a cook, a housekeeper, a social secretary, and a personal assistant, plus part-time staff for special events." "What happened to the staff?" "Starting in 22, Mr. Marshall began reducing staff. First he fired the personal assistant, then the social secretary, Alice Perdue, then the housekeeper. By 2004, it was just me and rotating nurses. Then he fired me too." "Why did he give for these terminations?" "He said Mrs. Astor didn't need so many people. He said she was too confused to notice. But that wasn't true. She noticed. She kept asking for Alice, for the housekeeper. She didn't understand why everyone was leaving." "Did the staff reductions affect Mrs. Astor's quality of life?" "Dramatically. With fewer staff, things didn't get done. Meals became simpler, often just frozen dinners heated up instead of the fresh meals our cook used to prepare. The apartment wasn't cleaned as thoroughly. Mrs. Astor's social life evaporated because there was no one to coordinate it." "Did Mr. Marshall explain why he was reducing staff?" "He said it was to save money. But it didn't make sense. Mrs. Astor had over $100 million. She could afford excellent care. The staff salaries, maybe $300,000 a year total, were a tiny fraction of her wealth." "So why do you think he reduced staff?" "Objection." Warner stood. "Speculation." "Sustained." "Let me rephrase," Seidemann said. "Did you observe where the money that wasn't being spent on staff was going?" "Objection. Lack of foundation. The witness isn't a financial expert." "Sustained." Seidemann moved on. "Mr. Ely, when you were fired in 2004, how did Mrs. Astor react?" Chris's voice broke. She cried. She held my hand and said, "Please don't go. Who will take care of me?" I told her Mr. Marshall would find someone else, but I knew it wouldn't be the same. She'd lose the continuity of care, the familiar faces. And I was right. After I left, staff turnover was constant. By the end of May, the prosecution had established that Brooke's living conditions had deteriorated dramatically under Anthony's care, not because of lack of resources, but because Anthony had systematically reduced spending on his mother while increasing spending on himself. Week 6-8. The Friends and Social Circle, May 25, June 12, 2009. Next came Brooke's friends, the people who'd known her for decades and watched helplessly as Anthony isolated her. Annette de la Renta, closest friend and court-appointed guardian. Annette de la Renta was perhaps the most powerful witness the prosecution called. She was elegant, articulate, and visibly heartbroken as she testified about her friend's final years. "Mrs. de la Renta, how long had you known Brooke Astor?" "Over 40 years. We met in the 1960s at a charity event. We became instant friends. For decades, we spoke almost every day. We traveled together, attended the opera together, supported each other through difficult times. Brooke was like a sister to me. What happened to your relationship with her in the early 2000s? Annette's voice trembled. Anthony cut me off. Starting around 2003, it became increasingly difficult to reach Brooke. When I called, Anthony would answer and say she was too tired or having a bad day. When I tried to visit, he'd make excuses. She wasn't feeling well. She had a doctor's appointment. It wasn't a good time. Did you persist? Of course. Brooke was my dearest friend, but Anthony was her son and had power of attorney. I didn't want to cause family conflict, so I deferred to his judgment. I thought he was acting in her best interest. When did you realize something was wrong? In early 2006, I finally insisted on seeing Brooke. Anthony reluctantly agreed. When I arrived at the apartment, I was horrified. Annette paused, collecting herself. The apartment was filthy. The beautiful rugs I remembered were torn and stained. The furniture was broken. And Brooke, my elegant, dignified friend, was sitting in a wheelchair wearing a stained nightgown. Her hair was a mess. She looked like she hadn't bathed in days. Did she recognize you? Tears streamed down Annette's face. No. She looked at me with these vacant eyes. I said, Brooke, it's Annette. She smiled vaguely but didn't respond. I realized she had no idea who I was. What did you do? I immediately called Philip Marshall. I told him something was terribly wrong, that his father wasn't caring for Brooke properly. Philip said he'd been trying to address the situation, but his father wouldn't listen. That's when I learned Philip was planning to file a guardianship petition. Did you support that petition? Absolutely. Someone had to protect Brooke. And you were eventually appointed her guardian by the court? Yes, in August 2006. What did you do when you took over her care? I restored the apartment. I hired additional nursing staff. I brought in specialists to address her medical needs. I invited her friends to visit. And I commissioned the forensic accounting investigation that uncovered Anthony's theft. Mrs. De La Renta, in your opinion, did Anthony Marshall act in his mother's best interest? Objection. Opinion. Your Honor, Mrs. De La Renta was appointed guardian by the court. She's qualified to offer an opinion about care standards. I'll allow it. No, Annette said firmly. Anthony did not act in Brooke's best interests. He acted in his own. Warner's cross-examination tried to suggest Annette had her own financial motives. Mrs. De La Renta, you were named in one of Mrs. Astor's earlier wills to receive jewelry, weren't you? Yes. Brooke left me some pieces as mementos, but they had sentimental, not monetary, value. And you were paid for serving as guardian? A modest court-approved stipend to cover expenses, yes? How much? Approximately $50,000 per year. That's a significant amount. It barely covered the costs of managing Brooke's complex affairs. I did it out of love, not money. If money were my motivation, I could have declined the appointment. But you didn't decline it, did you? Because Brooke needed me. And unlike Anthony, I put her needs first. David Rockefeller Jr., family friend. David Rockefeller Jr., grandson of John D. Rockefeller, had been friends with Brooke for decades. His testimony was brief but powerful. Mr. Rockefeller, when did you last visit Mrs. Astor? In the fall of 2005. I tried to visit several times before that, but Anthony always put me off. When I finally insisted, he allowed a brief visit. What did you observe? Brooke was a shadow of herself. She'd always been so vibrant, so engaged. But that day, she was confused and disoriented. The apartment looked shabby, very unlike the elegant home I remembered. I was deeply concerned. Did you speak to anyone about your concerns? I tried to speak to Anthony. I told him Brooke seemed to need more care. He was dismissive. He said, I'm handling it. But clearly he wasn't. Philip Marshall, the grandson, June 17, 2009. And then, in mid-June, it was Philip's turn to testify. Joel Seidemann called his name, and Philip walked from the gallery to the witness stand. His father watched him the entire way, cold, unblinking. The bailiff swore Philip in. "Please state your name for the record." "Philip Dayton Marshall. Died. And your relationship to the defendant?" "He's my father." A murmur rippled through the courtroom. "And your relationship to Brooke Astor?" "She was my grandmother." Seidemann approached the witness box. "Mr. Marshall, tell the jury about your grandmother." Philip took a breath, steadying himself. "My grandmother was extraordinary. She was brilliant, generous, funny. She funded libraries and parks and museums because she believed wealth should serve a purpose. She made everyone around her feel important and valued. She was the most remarkable person I've ever known." "How was your relationship with her?" "Very close. I visited her regularly throughout my childhood and adult life. She came to my school events, wrote me letters when I was in college, attended my wedding. She was a constant presence in my life." "What happened as she aged?" "Starting around 2001 or 2002, I noticed changes. She repeated herself. She forgot conversations. At first I thought it was normal aging, but it got progressively worse." "How did your father respond to her decline?" "Initially, he seemed concerned. He hired nurses and arranged for medical care. But then things changed. He started limiting who could visit her. He fired longtime staff members. He stopped inviting her friends." "Did you question these decisions?" "Yes, multiple times. I told him Grandma needed better care. He told me to mind my own business, that he was handling it." "What prompted you to file the guardianship petition in 2006? Philip's voice wavered. "In early 2006, I visited Grandma unannounced. What I saw horrified me. She was sitting in a wheelchair in a filthy nightgown. The apartment smelled terrible. There was dog waste on the floor. The nurse told me Grandma hadn't bathed in over a week because my father said hiring help was too expensive. My grandmother had $100 million, and my father claimed bathing her was too expensive. That's when I knew I had to act." "What did you do?" "I consulted with lawyers. They told me that if I suspected elder abuse, I needed to file a petition. So in July 2006, I filed to remove my father as guardian. That must have been a difficult decision. The hardest of my life. I loved my father. I didn't want to believe he was capable of exploiting Grandma, but the evidence was undeniable." "What happened after you filed the petition?" "My father stopped speaking to me. My brother Alex stopped speaking to me. Other family members accused me of betraying my father, of being motivated by greed. The media called it a family war. But I didn't care about public opinion. I cared about protecting Grandma." "Mr. Marshall, why are you testifying today?" Philip looked directly at the jury. "Because my grandmother can't speak for herself anymore. Because what my father did was wrong. And because he needs to be held accountable." "Your witness," Seidemann said, sitting down. Kenneth Warner stood for cross-examination. His approach was strategic. Paint Philip as vindictive and financially motivated. "Mr. Marshall, you expected to inherit money from your grandmother, didn't you?" "I never thought about inheritance. That wasn't why I did this." "But you knew you were a beneficiary in her will." "Yes." "And you knew the codicils your father arranged reduced your inheritance?" "I didn't learn about the codicils until after I filed the guardianship petition." "But once you learned, you had a financial motive to challenge them, didn't you?" "My motive was protecting my grandmother, not money." "How convenient. But the fact remains, you stood to gain financially if those codicils were invalidated, correct?" "I stood to see my grandmother's wishes honored." "Her wishes as you interpreted them?" "Her wishes as she'd stated them for decades." Warner changed tactics. "Mr. Marshall, isn't it true that you and your father had a strained relationship even before 2006? "We had disagreements, like any father and son." "Disagreements about your grandmother's care?" "Yes." "Disagreements about money?" "About how her money was being used, yes." "So there was pre-existing tension between you." It was concern about my grandmother's welfare. Concern? Or ambition? Didn't you want control of your grandmother's estate? I wanted her protected. There's a difference. Is there? Or did you see an opportunity to remove your father and take over? Objection. Seidemann was on his feet. Counsel is testifying, not asking questions. Sustained. Rephrase, Mr. Warner. Mr. Marshall, when you filed that guardianship petition, you knew it would destroy your relationship with your father, didn't you? I hoped he'd understand, but I knew it was a risk. And you took that risk anyway? Because protecting my grandmother was more important than protecting my relationship with my father. How noble, Warner said, his voice dripping with sarcasm. No further questions. Philip stepped down, his hands trembling. He'd survived cross-examination. But Warner had planted seeds of doubt. Was Philip a heroic grandson protecting his grandmother, or a vindictive son trying to usurp his father's authority? The jury would have to decide. By June 29, after weeks of emotional testimony from caregivers and friends who had witnessed Brooke Astor's decline and this treatment she endured, the prosecution shifted to the most decisive phase of the trial: the financial evidence. Their goal was to prove that Anthony Dryden Marshall, Brooke's only son, had systematically looted her estate while she suffered from advanced Alzheimer's disease. The forensic accountants, June-July 2009. Robert Brennan, a forensic accountant with extensive credentials, delivered the core financial analysis. Over 4 months, he had examined every account, transaction, and asset transfer tied to Brooke's finances from 2002 to 2006, years when her dementia was rapidly worsening. Through charts and records, Brennan demonstrated that Anthony's annual income from his mother's estate skyrocketed from an average of $200,000 a year, 1995-2001, to more than $2 per year after he gained power of attorney. In 4 years, Anthony received $9.10 million in gifts, loans, monthly allowances, and asset sales. At the same time, Brooke's own household expenses decreased dramatically, falling from $50,000 per month to $33,000. Anthony's allowance, however, soared from $16,000 to $83,000 per month. The numbers painted a stark picture. While Brooke's care deteriorated, her son enriched himself. Brennan also detailed the dramatic alterations made to Brooke's estate plan in the 2003 and 2004 codicils. Originally, her 1997 will allocated $95 million to charities and $15 to Anthony. The codicils reversed this balance. Charities lost $60 million, and Anthony's inheritance expanded to $75 million. Brennan found no documentation that Brooke requested these changes, despite the defense insisting they reflected her wishes. The prosecution then highlighted Anthony's orchestration of major asset transfers, including the sale of Brooke's prized child Hassam painting, Flags, Fifth Avenue. While it sold for $10 million, Brennan testified that $8 million quietly ended up in an account controlled by Anthony. Another major red flag was the sale of Brooke's main estate, Cove End, in 2004. Appraised at $2.50 million, Anthony sold the property for only $1 million to a close friend of his wife, who soon wrote a will that would leave the estate back to Anthony's family. Brennan called it a sham transaction designed to transfer Brooke's property to Anthony's household at a deep discount. The defense attacked appraisal variability and Brennan's compensation, but the jury appeared unmoved. The forensic evidence was clear, consistent, and devastating. The handwriting expert, July 2009. The prosecution next called forensic handwriting examiner Marilyn Resnick. She testified that Brooke's signatures on the codicils exhibited tremors, hesitation, and inconsistent pressure, all characteristic of signatures made by someone under physical guidance or duress. While Warner emphasized that handwriting science is not absolute, Resnick's analysis strongly reinforced the prosecution's theory. Brooke had not knowingly authorized the changes. The charitable organizations. Representatives from the New York Public Library, the Metropolitan Museum of Art, and the Bronx Zoo testified that the drastic reduction in Brooke's bequests made no sense given her lifelong philanthropic commitments. They also stated that Anthony blocked all attempts to speak directly with Brooke, claiming she was too frail. Their accounts further established that the codicils betrayed Brooke's long-held intentions. By July 10th, the prosecution rested, having called 72 witnesses and introduced 347 exhibits. Their case was overwhelming. Anthony had exploited his mother's dementia, enriched himself, and altered her will for personal gain. The defense case, July-August 2009. The defense strategy aimed to create doubt about Brooke's cognitive condition and the legitimacy of the codicil. Medical and witness testimony. Dr. Kenneth Stein, who examined Brooke once for 90 minutes in 2003, testified that she retained enough cognitive clarity to understand estate planning during that period. But on cross-examination, Seidemann emphasized Stein's limited exposure to Brooke, his $15,000 payment from Anthony, and the contradictory findings of Brooke's longtime physician, Dr. Phillip. Attorney Harvey Korn, who witnessed the 2003 codicil signing, claimed Brooke appeared competent. Yet he admitted he did not know whether she read or understood the document. Alec Marshall's testimony. Perhaps the most emotional defense witness was Alec, Philip's twin brother. He depicted Anthony as a devoted son and caregiver. But Seidemann exposed Alice's financial dependence on Anthony and underscored that Alec rarely visited Brooke in her final years. His credibility evaporated under scrutiny. Charlene Marshall, Covent buyer. Charlene denied any scheme in the Covent purchase. But when the prosecution produced the will, leaving the property to Anthony's wife, her testimony collapsed. Anthony Marshall takes the stand, August 2009. Anthony's testimony was the climax. He portrayed himself as a loyal son, following his mother's wishes and caring for her lovingly. He insisted that the millions he received were gifts and that Brooke was competent when she signed the codicils. But under Seidemann's cross-examination, Anthony's narrative unraveled. The prosecutor confronted him with the financial discrepancies, Brooke's declining care, the lack of documentation for the alleged gifts, and expert testimony showing Brooke was incompetent at the relevant times. Seidemann's final line of questioning emphasized isolation, control, and motive. Anthony had not acted in Brooke's best interests. He had acted in his own. The damage was irreparable. Closing arguments and verdict. In closing, Seidemann delivered a powerful argument that framed the case as one of betrayal and greed, supported by overwhelming evidence. Warner countered by highlighting doubts, subjectivity in valuations, and emotional manipulation by the prosecution. After deliberating an extraordinary 43 days, including conflict among jurors, the jury returned on October 8, 2009. Anthony Marshall was found guilty on multiple counts, including grand larceny and conspiracy. His attorney, Francis Morrissey, was also convicted. Philip cried as the verdict was read. Anthony remained expressionless. Sentencing and aftermath. On December 21, 2009, Philip delivered a victim impact statement describing the deep pain of watching his grandmother exploited and the emotional cost of turning against his father. Anthony addressed the court with defiance, denying wrongdoing. Judge Bartley sentenced Anthony to 3 years in prison and ordered $4 million restitution. Morrissey received the same term. While appealing, Anthony remained free until 2013. After his final appeal failed, he served 2 months before being released on medical parole. He died in 2014 without ever apologizing. The fraudulent codicils were invalidated, and the original 1997 will was reinstated. Charities received the full $60 million Brooke intended for them. Philip's family remained fractured for years, though he and Alec eventually reconciled. The case spurred national reforms, including the Brooke Astor law, which strengthened protections against elder financial abuse.